Hello, learners. Welcome back to our AIBE preparation series. This is Licit World, and today we are diving deep into one of the most dynamic and powerful areas of the Indian Constitution: emergency provisions and their impact on the federal structure of India. Have you ever wondered what happens when our country is on the brink of war or when a state government fails to function? Who takes charge? And what powers does the center hold? That's where emergency provisions come in. Let's start with the basics. Emergency provisions are contained in Part 18 of the Constitution from Articles 352 to 360. They were designed by our framers to ensure the government can act swiftly and decisively in times of grave national crisis. There are three types of emergencies: national emergency, Article 352, President's Rule, Article 356, financial emergency, Article 360. These provisions temporarily centralize power in the union government, overriding normal federal principles. Sounds intense? That's because it is. Let's unpack each. A national emergency can be declared if India's security is threatened due to war, external aggression, armed rebellion. Previously it's known as internal disturbance. During a national emergency, the center assumes wide control. The state list becomes open to the parliament, allowing it to legislate on subjects normally reserved for the states. Article 19, which ensures our fundamental freedoms, can be suspended. There's a case, Minerva Mills vs. Union of India, 1980. In this case, the Supreme Court clearly laid down that even during an emergency, the Constitution remains supreme. Judicial review cannot be suspended, as it's part of the basic structure doctrine. So yes, the center becomes extremely powerful during a national emergency, but there are constitutional checks. Now let's move on to the President's Rule, also known as state emergency. This is invoked when the President is satisfied that the government of his state cannot be carried on in accordance with the provisions of the Constitution. And here's the impact. The state legislature is either suspended or dissolved. The state is governed directly by the President through the Governor. Parliament makes laws for the state. Now let's talk politics. This provision has been heavily misused in the past, especially by ruling parties at the center to dismiss state governments run by opposition parties. There is a landmark case, S.R. Bommai vs. Union of India, 1994. This case changed everything. The Supreme Court ruled that the imposition of President's Rule is subject to judicial review. The floor test in the assembly is the correct method to prove majority. This case was a victory for federalism and a check on arbitrary central power. Now let's discuss financial emergency, which interestingly has never been declared in India. This can be proclaimed when the financial stability or credit of India or any part is under threat. Impact: salaries of government servants, including judges, can be reduced. Money bills of states can be reserved for the President. The center can control financial matters of the state. While it remains unused, the potential impact on state autonomy is huge. Let's address the core theme. How do emergency provisions affect the federal nature of our Constitution? India is often called a quasi-federal state. That means it's federal in structure but unitary in spirit. Emergency provisions highlight this unitary bias. During emergencies, state governments lose legislative and executive authority. The Union can override decisions and laws. The Parliament gets temporary power over state list subjects. So, in short, the federal balance tilts heavily in favor of the center. But the Constitution isn't blind to these dangers. There are safeguards in place. 44th Constitutional Amendment 1978 added that a national emergency can only be proclaimed on written recommendation of the Cabinet. Article 19 rights are no longer suspended automatically. Emergency requires parliamentary approval every 6 months. There is a judicial oversight. Post SR Bommai, President's rule can be challenged in court. So, while the provisions are strong, they are not unlimited. Let's sum up. Emergency provisions are a constitutional necessity. They allow for strong, centralized response in crisis. However, they are also potential tools for abuse, capable of dismantling the federal fabric if unchecked. As an AIBE aspirant, remember article numbers 352, 356, 360, key cases, Minerva Mills, SR Bommai, role of 44th Amendment, and most importantly, balance is the essence of our democracy. I hope this breakdown helped you understand not just the legal structure but also the constitutional philosophy behind emergency powers. If you found this lecture helpful, don't forget to like, share, and subscribe for more AIBE content. Until next time, stay informed, stay constitutional. Thank you.